Hello everyone, good day according to your time. Welcome back to Learning is the Key. Please, if you're seeing my channel for the first time, don't forget to subscribe and hit the notification button. Please follow my page just so that God bless you. So it don't happen. And I know say something we didn't do. It get where they go do and reach. You go come start with the return to the people where PC they do. So na never hear, I don't know what thing they happen. Courts don't deny INEC the appeal we do. Say making reset Bvas. They don't tell and say no. Make it live on the way we did. Because in tell us say the election was fair and it was free. So if it was fair and free, it should leave it the way it is. They cannot reform anything now. Guys, this is one of the best news I've ever heard this year. This is really wow. I couldn't believe it when I saw this video. So for those of you that have not seen this video, I will give it to you now. You will see it yourself and you will understand that in life, too much of everything is bad. What Nigeria do now? Heartless people like Una. Una never reach to go retire. Abuna not get a retire for her own. Ah, God.
Most of the labor is friends. Okay? You understand? It's fine. My friend. Sorry. Sorry.
We are here for a ruling on the application by INEC, particularly to vary the order of the ex parte order procured by Labour Party and Mr. Bvas to enable them procure vital evidence required for their petition. INEC filed an application seeking to vary those orders, particularly as it relates to the server, Bvas machine. Luckily for us today, the court refused to vary that order. That order is sustained and remains. In another ruling, the court was of the view that they are given the back-end server, which INEC undertook to provide to secure those materials, that order is partly sustained. Those initial orders are partly sustained. But in all, the good news is that the initial order of the court made on the 3rd of March, permitting Peter Gregory and Labour Party to inspect the facilities of INEC, including the Bvas machine, which they intend to use to prove their petition. Those orders are sustained. The application seeking to vary it was refused. So that is the story for today. Thank you, gentlemen. No. My name is Ben Anachobe.
Yes, sir.
Yes.
You are okay.
Yes. Well, you will recall that an ex parte application was argued by Atiku and the PDP, and it was granted by the Court of Appeal. And several orders were granted to have forensic examination of the Bvas, the devices, the back ends, and also to have access to all the storage in the cloud, IREVs, the portal, and in addition to having photocopies and scanned copies of the ballot papers and all election material that were used during the 25th February presidential and National Assembly elections. Now, to our greatest surprise and advantage, having worked in the last few days, having burnt midnight candle to oppose the application by INEC to vary that order, which we cherish, somehow they withdrew the application by themselves. and it was struck out. The question is, what is the implication? What is the legal implication of that withdrawal and eventual striking out of their motion on notice, which brought us to court today? That simply means that the reliefs granted by the court on the 3rd of March 2023 stand. In other words, they have to comply with the orders of court and allow us have access. And we need just 7 days to have all that we need. Because without exercising our right to have access to all these reliefs I've mentioned, that simply means that our petition is indirectly being affected. We have a right under the Electoral Act, particularly sections 122, 146, as well as 74, to have access. And fortunately, they have withdrawn. And of course, section 36 of the Constitution allows fair hearing to everyone, particularly in these circumstances, the petitioners or prospective petitioners who have been the applicants before the Court of Appeal. And alas, this threat, this hindrance and inhibition on our way has now been withdrawn by itself, by those who filed the motion. So let's see what happens in the next few days. We'll be reverting back to INEC, asking them to comply with the court orders, orders that were granted, orders that remain valid and subsisting till date and beyond today, by the grace of God.
Today that refuse to restrain INEC from the constitution.
That's not our case. That's not our case.
Well, we are not in that case.
Yeah.
And that case had different prayers, different parties. We are concerned with ours. Our focus is restricted to the case we have filed and considering the parties we are representing. So that is all I can say about that. I don't know the implication of that one. We haven't seen the copies. We are yet to see the orders of court or the ruling of court that was just delivered shortly before ours. We are not parties to that. And parties are bound by the rulings or orders or decisions in the case
And
they
their
appear.
pleadings.
And their pleadings, of course. You can't have rulings without pleadings. I've said so earlier.
Wow.
We are here to represent Atiku Abubakar and People's Democratic Party. You're most welcome.
Let's go.
He's not the bad one. This is the bad one.
Yes. That's yes. Yes, we are here for you.
Finally, INEC has got its mission. How do you feel? And so what does this mean for the INEC conduct of the election?
What it means is that, yes,
Come down.
go down. Okay. What it means is that the fears of Nigerians is allayed because we're going to conduct governorship election as scheduled by INEC. We have 2 elections on that day: governorship election and state houses assembly election. These are what we are going to conduct on the 11th of March, inshallah.
Okay, so let us be clear. Did the court grant you permission to reconfigure the Bvas?
Certainly, because what the application of Peter Obi and Labour Party was that we should be stopped from tampering with the Bvas machine. We now, before they finish the inspection and all those things, our ICT expert deposed to the PDB that no, reconfiguring the Bvas machine will not tamper with the data contained this, because we are sending the data to our back-end clouds and server. And there was no counter affidavit or further affidavit to controvert what we say. The court has no option than to accept what we are saying as the position of the law and the true position. So this is what happened.
Okay, sir, lastly, in the
Yes.
case that involved the PDP
Yes.
and INEC,
Yes.
we were just told by the senior advocate
Yes.
that the court granted permission for them to conduct forensic examination of the sensitive material like the Bvas.
Well, you see, there were two motion rulings today. One by INEC and the other one by Peter Obi and Labour Party. In the INEC motion, which was though dismissed, but the court was able to clarify the order it made. Our fear, or our fears was that what they are seeking may lead to identifying how a particular voter voted in last 25 February election. Because what they wanted to do from our understanding of the order was that they need forensic analysis of the ballot papers, one, and then they want to have access to our cloud, which have the biometrics data on all voters. Now, if you match the ballot paper with the forensic analysis of our cloud, it will definitely show you how a voter voted, because to show the fingerprint of the voter. This is how a voter voted. This is what we wanted to protect. And the court said, no, that is not what it ordered. What the court ordered was that they can have access to the election materials, such as ballot paper, result sheet, and any other material that was used for the election, not that to have access to our cloud or database. That's what I want.
That prompted the withdrawal of your motion to
Of course, because we don't want to belabor the court again, because in the same order granted to PDP. So if we are to move the court will repeat what it said. So why wasting the very precious time of the court? And you could see that we are here since when? Getting to 7 o'clock now. Thank you very much.